Good afternoon, everyone, and welcome to a special meeting of Brant County Council of October the 28th, 2025 at 4 o'clock. Attendance has been taken, noting that Councillor Coleman is tied up in traffic somewhere between here and home, and Councillor Chambers isn't coming. So that takes care of attendance. And approval of the agenda, please, noting that nothing can be added to the agenda because it is a special meeting. Can I get a motion? Councillor McAlpine, Councillor Kyle, all those in favor of the agenda the way it stands? Thank you. Pecuniary interest, if you see one crop up, please let me know. We have a delegation who is going to be our speaker. It's a session on education. It's John Pappas, and he's going to come up and talk to us about all things election. And there's going to be a question period at the end, so I don't know whether you can people ask questions as you're speaking, or do you want them to wait until the end?
Good, thank you, Mr. Mayor. I did have a generous portion for question and discussion at the very end. Okay. So I've reserved something like 20 to 30 minutes for that. So if absolutely necessary, or if it's a question of clarification, by all means jump in, but otherwise if there are subject matters or concepts you'd like to discuss, we can save that toward the end.
Thank you.
Okay.
So if I can get a motion, please, before we begin, Councillor Pearson, Councillor Kyle. Okay, all those in favor, and we're going to, you can take it from here.
Thank you very much, Mr. Mayor, and thank you, members of council, for having me this afternoon. My name is John Pappas. I'm a municipal lawyer with Aaron Burles in Toronto. A good deal of my practice involves municipal ethics, so the Integrity Commissioner regime, and advising council on accountability and transparency and the topic of good governance generally. And in addition to that, a large part of my practice is election law. So this topic we're going to be discussing today is the perfect synergy of both. It deals with ethics, it deals with election concepts, and overall it deals with good governance as a municipal council. What I'll be discussing today is navigating the dynamic of dealing with an election period while still dealing with council business and still serving in your official role as a member of council. As I mentioned, my presentation, the substantive presentation, will go about 30, 35, 40 minutes, something like that, but I've reserved a good portion at the end to discuss any questions. So we'll get started with, I think, at a principled level or at a higher level, what it is you do as a member of council. You have an incredibly difficult role. You have to listen to your constituents and represent their views and come together with all your colleagues to make decisions that further the public interest. That is the key role of a member of council, and that's what Mr. Ian Rogers, in the seminal textbook on municipal law in Canada, notes as the position of a member of council. While serving on council, members are under a duty to act in the best interests of the corporation, that being the municipal corporation, and the citizens they represent. And that relationship, standing in the place of a councillor vis-a-vis the electorate, that's what's been described in a number of different cases as a fiduciary duty or fiduciary responsibility. And in a case called Sims and Fratesi, dealing with the Municipal Conflict of Interest Act, Justice Pupor of the Superior Court, or sorry, the General Division at the time, noted that it is argued, and this court does agree, an elected official stands in a fiduciary relationship with the electorate. So a fiduciary relationship is a concept you may have heard about oftentimes in trustees or finance, where one agent sits in a decision-making capacity for someone else, but they don't serve, or they can't serve their own interests. They must advance the interests of the other party over their own. And in this case, Justice Pupor describes that duty. That is a duty to act in the best interests of the electorate and not permit any conflict with a member's personal duties. That's discussed ad nauseum in the case law about conflict of interest, but this also applies in this context as well. The last excerpt I'll take you to is a more recent discussion of this idea or of this concept, and this comes from Chief Justice, our former Associate Chief Justice, Frank Morocco, in the Collingwood Judicial Inquiry that was conducted about 5 years ago now. And there's a lengthy discussion of the nature of the position of a member of council, including head of council. And what Associate Chief Justice Morocco said was, councillors, members of council, including the head of council, are trustees of the public interest. And council members must ensure that this trust governs their actions and their decisions. So not only the decision-making function that you serve when you come together with a quorum of your colleagues to make decisions, but also your actions and how you're conducting yourself in the public. That's the ethics component of our discussion today. But as we all know, putting aside any member of council who's been appointed, which I don't believe there's an appointed member. I think everyone's been elected on this member or on this council in this term. Members of council only come to this position because they have been elected, because they've run in a municipal election or a by-election, and they've been successful through that endeavor. And so the purpose of those elections is described in this case, Cummings and Martin, which is a more recent decision. The purpose of elections is to allow the residents of any particular municipality to exercise their democratic rights to participate in choosing elected officials. And once municipal council is constituted by way of individuals assuming the municipal office to which they were elected, the powers of the municipality are thereby or thereafter vested in council. So you have the description of what a councillor needs to do, what a member of council needs to do to act in the best interests of the public, but recognizing there's an inherent tension. You're all private individuals. You go home to your residence at night. You're wearing two hats, effectively. You have your personal role, and you also have your public role. And at times, it's incredibly difficult to take off the public hat, right? Your public persona of being a member of council. That other hat, the private role, manifests through the election activity that got you all here. Running for office, seeking any office, that is not part of the quote-unquote official duties of a member of council. It's inherent in how we got here, but that capacity is entirely private and personal. So when you're seeking election to office, you're doing so in your individual private capacity. And this was described in a couple of cases. I won't belabor the point, but there are two cases where the courts confirmed this notion. The first is a case called Santa and Thunder Bay, about 2 decades ago, where an individual member of council was elected, and after being elected, there were campaign finance allegations made against them. So there was a compliance audit of this councillor that was rejected, and then some parties went off to court to sue him personally. And the councillor argued that he should be entitled to insurance proceeds from the municipality because, of course, he was a member of council. He was being sued because he was on council, because he was successfully elected. And the court said, no, under the then 1990 version of the Municipal Act, and that gets carried through today, insurance can only be provided to members of council for acts or omissions that are that occur or that come up in their official capacity as a member of council. And what the court said there is seeking office and being elected to office predates that official capacity. A member of council only becomes a member of council for that term once they swear their oath of office. This is something you've all done, swearing your oath at the inaugural meeting. And up until that time, you're acting in a private capacity. Even if after an election and through the campaign finance regime, through the compliance audit regime, issues may come up and you may be targeted, councillor may be targeted because they are a member of council, because they were the incumbent. Those actions and that activity all takes place in a circumstance or in circumstances that predate your election, predate your term of office. In a more recent case, and I say more recent, but this was still 15 years ago, still good law, Holiday in the City of Toronto. What happened in that case was 2 members of council got caught up in campaign finance proceedings and compliance audit proceedings. And the City of Toronto wanted to reimburse these 2 members of council their legal fees for having defended themselves. Councillor Doug Holiday disagreed with council doing this and brought an application to court for a declaration that council's actions were unlawful. Under the City of Toronto Act and under the Municipal Act, a member of council is entitled to be reimbursed for expenses that they incur in performing their duties, but those expenses must relate to their official duties as a member of council. And what the divisional court said in this case was, even where a candidate is successfully elected, any election campaign activity is not part of a member's official duties. So we have these 2 roles. To summarize again, when you're running for office, even if you're successful after the fact, anything related to that activity, that purview, is purely private. It's not part of your official capacity. So there's a dual aspect, or what I'll call a double aspect, to a member of council in their role during an election year. Of course, council's still running, council's still holding meetings and making decisions, subject of course to the lame duck rule in the Municipal Act. And members of council are still expected to attend those meetings and serve in their official capacity. Members of council still also represent their constituents during that term of council. But again, because members only hold office because they are elected following an election campaign, there is a tension between using the role or serving in the role of the trustee of the public interest versus serving your private interests, your own private interests in being re-elected to office. What we're going to be discussing today are some guiding principles on how to reconcile those two different capacities. I'll say that in my own observation, my own professional experience, this topic, this area of what I'll call, not necessarily law, but principle, doctrine, it's received very little attention, but in my view, I think that's a bit of a disservice because this is an incredibly important period of time. It's a sensitive period of time for the electorate. And frankly, it's when the electorate can lose confidence in municipal institutions if they see private interests leading the way over the public interest that's expected to be served. A couple of other things that I'll mention. What we're talking about today, it's akin to, it's slightly different from what some of you may have heard, I think in February of this year, called the Caretaker Convention in parliamentary government or parliamentary politics. So earlier this year in February, we had a provincial election. And in the media, there was quite a lot of criticism about Premier Ford having made certain policy announcements or undertaking policy decisions while still running for election. The Caretaker Convention is something that is a soft law or a constitutional convention or principle, so it's not written and codified in a statute like the Municipal Conflict of Interest Act or the Drainage Act, something like that. But it's a convention that guides parliamentary governments. And what it provides for is that where there's an election period being held, ministers, members of the government are expected to refrain from using their role, using those positions to advance partisan activity. And a lot of it deals with making decisions, substantive decisions about policy matters or financial commitments that can't easily be undone by the next government, but it also relates to the use of government resources in seeking re-election or in supporting partisan activity. And this all comes to bear even if a member of council does not intend to seek re-election. These principles and the public's view of the proper functioning of municipal institutions is still visited on the corporation and on individual members of council. So a few potential issues that can come up, and these will be fleshed out a little bit more as we work through our material today. Members of council, of course, by virtue of being elected and holding their official position with the municipal corporation, they have access to resources that the public may not. So they'll have, for example, an @Brant County or @Brant.ca email address. There are access to staff resources, municipal corporate resources that a layperson or a general member of the public would not ordinarily have access to. And this also harps on the public policy that underlies municipal campaign finance law in the Municipal Elections Act, which is something you'll hear me discuss as well. That policy provides for, or the goal of, putting all candidates on a level playing field. And often this comes from a perspective of leveling playing field by a candidate who's independently wealthy or backed by deep pockets, but it also deals with incumbency and individuals who might have access to corporate resources that someone might not. The second, again, that the general good governance principle is that members of council must serve and be seen to be serving the public interest above their own personal and private interests. And that transcends, as you heard me say, transcends the decision-making function that council plays and also applies to the personal conduct of a member of council. And lastly, the public ultimately must have faith that municipal institutions and government will serve the public interest and not any private interest. And at times, it can be difficult for members of the public to discern what capacity a member of council is acting in, whether they're saying something or doing something in their official capacity as a member of council, or whether they're acting in a purely private manner. These are the two hats that I talked about that might not be easy to take off. So I'll start with a document which I'm sure all members of council are familiar with. This is a document that's been printed and circulated around. This is the county's code of conduct. And in reviewing the Code of Conduct, I think there are 3 provisions that are most relevant to this discussion today. And that's not to say that the remainder of the Code of Conduct doesn't apply or can't apply, but three provisions that I think provide the most guidance. Before I get into the substance of it, I did want to address one thing about codes of conduct generally and the Integrity Commissioner regime in the Municipal Act. I've heard on more than one occasion that there's a misconception that the code of conduct just doesn't apply during the election period. As soon as the nomination day comes, there's no more code of conduct, we don't have to care about it, we don't have to think about it. That's entirely wrong. There is a provision, we call it the blackout period or the blackout provision, where complaints can't be made to the Integrity Commissioner or the Integrity Commissioner can't continue on with an investigation after nomination day in an election year, so that's the date in October. But those can resume after voting day or 6 weeks, up to 6 weeks after voting day. That's not to say the code of conduct does not apply in that period, because it certainly does. And there can certainly be things that happen or occur during that period of time that can give rise to a complaint after voting day. So the first provision I want to speak to is Section 10 of the code. And by all means, feel free to flip there or not flip there. I don't mean to go into each provision in great detail or read them out. You guys, you members of council all have a copy and can certainly access it when you want, but I want to highlight some of the salient parts of each of them. Section 10 generally prohibits the use of county property, which is a defined term, for any purpose other than the business of the county. And that's something that the members of the public would expect. Public resources are to be used for a public purpose or to further the public interest, not for private benefit or for some private advantage. The code defines county property, and it does so fairly exhaustively. And this can include facilities, equipment, supplies, services, information, member expense funds, which are a critical component of this, county computers and devices and websites, and the lot. Section 10 also prohibits seeking or obtaining a quote, personal benefit from the use of county property, county-owned images, logos, or the IP of the county. And personal benefit is interpreted to mean any non-financial advantage. So not necessarily something that the Municipal Conflict of Interest Act would govern through a pecuniary interest, but some private advantage that a member might obtain. And the section of the code doesn't expressly speak to the election period, but it builds very well on the county's obligations under the Municipal Elections Act. Under the MEA, the county as a municipality is not permitted to make campaign contributions to a candidate. And a campaign contribution could include goods or services that are provided in kind to a candidate. Those are not permitted under the Act. And to help manage this, what the Act says is that every municipality must establish rules and procedures respecting the use of municipal resources during an election campaign. And that's where the county's municipal use of resources procedure applies. And this is the second document that's been circulated to members of council. It applies to all candidates, so not just members of council, but all candidates and staff during a municipal election campaign period. It deals with corporate resources, assets, and funds, and it generally provides that those shall not be used for campaign-related purposes. The language of the policy, or the language of the procedure, provides for campaign-related purposes, not necessarily campaigning or campaign activity, but it's broader than that because it seeks to address any number of ways that corporate policies might be accidentally or inappropriately deployed in an election or in an election period or context. So some examples of what cannot be used are county-owned cell phones, county email addresses, county-supported personal websites and social media. It includes photos produced by or for or owned by the county's intellectual property, and in addition, contact lists or distribution lists that are developed by the county. So this could be things like an email list or in sort of the olden days, a Rolodex of sorts. There's some exceptions to this. Policy does make some exception for candidates identifying themselves. It says you cannot use a crest or a logo or a uniform that is used or belongs to the county, but you can identify yourself in your role as a member of council or if you're on a committee, as a member of that committee, but only to say that you've served in that role. Another exception, which dovetails, I think, very, very well with the campaign finance rules in the Municipal Elections Act, are that rented facilities are exempted from this, provided that there's a rental fee paid. And again, this makes good sense with the overall leveling of the playing field, because if any other candidate can also access or obtain the benefit of renting a facility, then there isn't a concern that a member of council has an advantage over another. So failing to comply with this policy, again, it's a policy document. It's not a statute. It's not a bylaw. It's not as though a municipal law enforcement officer is going to come around with a ticket book and issue tickets. There are two issues or two consequences for failing to comply that I've identified at least. The first, and I think the overarching view, is a potential loss of confidence in the electorate. And I think arguably that's the most important thing. You've heard me say this, and I'll say this probably three or four more times during my presentation. Members of the public expect that public resources, government-owned facilities, government resources are going to be used for a public purpose and not for the purpose of benefiting some private party. And so where a member of the public sees that county resources are being used for an election campaign, that is immediately going to trigger significant scrutiny. And that's not just going to be visited on the individual that might be using them, but also on the institution of government as a whole. How did that happen? How was this allowed to happen? That's not fair. Things like that will be raised. The second and the more pressing concern deals with the compliance audit regime and the campaign finance rules under the Municipal Elections Act. By a 30,000 foot overview of how that happens, presumably you've all filed financial statements with the clerk after the last election. Any elector of the municipality can file an application for a compliance audit to the municipality's compliance audit committee. And if the compliance audit committee believes that there is a reasonable and credible grounds to believe someone's contravened the campaign finance rule, they can issue an order that the candidate be audited. And this isn't just a turn over your books. This can be potentially a very intrusive investigative audit of all of your campaign finances, and including to some extent where there's a blending or not a fine demarcation of personal spending and campaign spending. An auditor has powers to uncover the whole lot. And this could eventually relate or result in charges in the provincial offences courts for violating the Municipal Elections Act. The allegation, of course, being that if someone's using municipal property for which they haven't properly attributed a value to, they've gotten an advantage, or they have undeclared expenses or undeclared contributions. That is a significant and burdensome process that you all want to avoid. Having practiced in that area a lot, I can say that even the minor things can trip up candidates and members of council, and that's why it's incredibly important to be diligent through the campaign period with all campaign activity. So the next provision of the code that I'm going to turn to is Section 11, and this is the more express or explicit provision of the code dealing with election campaign work, as it's phrased. Section 11.1 provides for exactly what we've just discussed, is that all members are required to follow the provisions of the Municipal Elections Act. So principally here, these are the campaign finance rules that are visited on all candidates. And secondly, 11.2 provides that members cannot use county resources for any election campaign or campaign-related activity. So this is the more specific rule of the two in the codes dealing with the use of corporate resources in an election period. Again, it says campaign-related activity, so not necessarily just active campaigning, the fact of being on municipal property with a leaflet or with a sign saying "Vote for me." It could apply to prep work, conceivably. And what it covers, a broad swath of things. It includes the county's phone system, councillor newsletters, councillor websites. It runs the gamut. In addition to that, the last area that's regulated by this provision is the use of staff resources. And the code prohibits a member from using the services of a person working for the county, so for example, a member of staff, while they are on county time. The last provision is Section 13.1 of the code, and this deals with the improper use of influence. There's a certain level of clout or power associated with a member of council's office. And the public expectation is that level of influence, that influence is meant to serve the public interest. It's not meant to serve private interests or private advantage or to try and seek private advantage. And that's what section 13.1 of the code seeks to prohibit. So 3.1 provides that members cannot use the influence of their office for any purpose other than their official duties. And official duties is defined in the definition section of the code. Essentially, it's the public duties of a member, including functions necessary to demonstrate responsible and accountable government with respect to county matters, and done for the purpose of providing good government with respect to these matters. This, and I'll be very clear, this does not include seeking election or seeking re-election. It does not include campaign activity. Section 13.1 and 13.2 again provides that members shall not use their office or position to improperly influence the decisions of others to secure a private advantage. One example I'll think about, and so this harkening back to my law school days, this is a case that it's taught in day one of public law or of constitutional law. It's a case called Roncarelli and Duplessis. And it was a case in the 1950s out of Quebec where an individual who was a Jehovah's Witness was distributing religious material or campaign material, and they had made a license application to the Quebec's liquor licensing board at the time. And the premier intervened in that application process and said, I don't like what this individual stands for. You, licensing officer, need to decline this license. And they went ahead and did that. And the court went back to first principles, and this is a very long time ago. This is in the 1950s. And what the court said is public powers need to be exercised for a public purpose. And the individual direction that was given to that licensing officer was entirely inappropriate. That's just one example of what could happen, right? There could be an instance where a member of council is really harping or harassing and this is something that has happened in the past, harassing a bylaw officer to go out and enforce a signed bylaw against the opposing candidate in the election. And you're certainly entitled to make a complaint and leave it at that, but you can't interfere and try and impress your influence of your office to achieve a certain outcome for a private advantage. So that's just an example of something that could be engaged, some activity that could be engaged by this provision of the code. So everyone likes some stories. So a few stories to tell about some examples where quite notable politicians at the municipal level and other levels have gotten themselves in trouble with the code. So former Mississauga Mayor Bonnie Crombie in 2014 ran into some trouble with the Integrity Commissioner of the City of Mississauga. She was found at the time she was moving from a Ward 5 councillor to, of course, mayor of the city. She was found in contravention of the Code of Conduct because she included links to her campaign website and her campaign Facebook page in a city-maintained website, and city-maintained or official capacity is what I'll call it, Facebook pages promoting herself as a councillor at the time. Under Mississauga's Code of Conduct, it had a policy prohibiting the use of public funds for campaigning, and the fact of the dissemination of this newsletter, the hosting of the Facebook page, and the use of municipal resources to run that page, that was found to be a code contravention. So interestingly, when this came up, shortly after the complaint was made to the Integrity Commissioner, Mayor Crombie, or at the time Councillor Crombie, took down that page. So she removed or scrubbed the information off the website. And the Integrity Commissioner, although he found a code contravention, recommended that there not be a sanction because there had been remedial action taken. So another instance where something similar has happened is the late Mayor Ford in Toronto. So at the time in the 2014 election, Mayor Ford had initially put his name in the hat for another run at the mayoral seat, and then stepped down and ran for Ward 2 councillor, so the North Etobicoke ward. And at the time, again, infamous for his position on not using public funds for constituency outreach efforts or councillor's office expenses, Mayor Ford ran a constituency newspaper. And when he was elected to Ward 2 to serve council, his campaign ended up in a deficit. So he extended his campaign period in order to erode that deficit or pay off some of the campaign debts. And he was holding a fundraising function, a campaign fundraiser, in order to gain some funds to pay off that deficit. This ended up being promoted in his Ward 2 constituency newsletter. And despite the fact that this newsletter was performed by, or published by, or prepared by the Chief of Staff on his own time, so not while being paid by the city, but on his own time, and the fact that all of these costs were being paid for by Councillor Ford, then Councillor Ford, personally, so not with a councillor expense budget, that was still found to contravene the provisions of the code on election activity. The newsletter was still considered to be part of then Councillor Ford's official capacity as a member of council, and not, even though he was paying for it personally, even though it wasn't being prepared on staff time, that was still seen to be part of his official capacity. So those are just some examples of where members of council have been tripped up in the past. So the back half of my presentation, I'd like to focus on some more discrete or more specific topics. The first is declaring candidacy. Under the Municipal Elections Act, an individual only becomes a candidate after filing their nomination paper with the clerk. And that can be done as early as May 1st in an election year. The Act does not directly prohibit declaring an intent to run for election, or saying that, yes, I will be on May 1st, on May 4th, I guess is the Monday, I will be filing my paperwork, whatever the case may be. That said, the campaign finance regime would still apply. So campaign finance activity, whether that's accepting contributions or incurring expenses associated with any campaign activity, that cannot occur outside of the campaign period, which is the earliest of filing your nomination paper or nomination day. So some guidance that some other sources have provided and what I provide in the circumstances. First and foremost, the best, or the rule of thumb, is to refrain from announcing or formally announcing an intent until your candidacy is official. It's not official as of that date, and after that date, you're allowed to incur expenses. So do what you wish, hold a presser, have some sponsored posts on Instagram, whatever the case may be. Prior to that, there could be issues that you run into with allegations of early campaigning. Secondly, announcements should not be made using county resources in any sense. And this applies based on the language of the code, based on the language of the municipal use of corporate resources policy. To the extent there's any county resources that are being used to make that announcement or to declare that intent or declare that you have filed your nomination, that would be improper. That would blend or improperly obfuscate the two roles, the official capacity and the personal or private capacity. And again, announcements, I've said this before, but to circle up, announcements that require or involve spending money could be considered a campaign expense under the MEA. And if that's done in advance of the campaign period, that could give rise to some allegations that there are campaign finance contraventions. So the second specific topic is social media, and this is a big one because in the present day, this is the most prevalent mode of communication during an election campaign period. And as members of council, I'm sure you'd agree, it's also a very easy way to communicate with your constituents or to understand, keep your finger on the pulse of what's going on in the public. So this can include anything from Facebook, X, or formerly known as Twitter, Instagram, TikTok, you name it. It could run the full gamut. I don't know if anyone has a TikTok page here as a member of council, but some do. I know that there are some members of council, or some heads of council that have TikTok pages. But in addition to that, members of council might also have an official account for exactly that purpose, for communicating ideas or updates to constituents, receiving feedback and understanding what the public desires of the county. That resource or that account can be seen as something that's either been developed in your official capacity or belonging to the official capacity of a member of council, similar to a distribution list, an email distribution list or Rolodex. And it could also contain, in large part, municipal corporate property. And you can think of something as simple as, or something as innocuous as a picture that was taken at a council meeting that's been posted some number of years ago, but it's still on your page. And you can still see a county logo or county emblem, and a photo on county property. That could still be considered under the code, under the procedure. That could be considered municipal corporate property. And so this is an issue that one of the first municipalities that really visited and dialed in on this issue was the City of Toronto. And there, the city's integrity commissioner and municipal clerk undertook a joint review of social media use policies back in 2015 and 2016, and a joint bulletin and a report from the Integrity Commissioner were issued. And the advice that was given by Integrity Commissioner Val Jepson at the time, who's now actually a judge of the Superior Court, what she said was existing guidance for elected officials at the municipal level focuses on maintaining a clear separation between social media use for election purposes and social media use for official city business. And again, this is the two hats that we've been talking about. It's difficult for a member of the public to understand, I'm making this comment in my official capacity, or I'm making this comment in my personal capacity. It can be something as innocuous as saying, you know, the Jays blew it last night, or the ump made a terrible call last night, and I you know, things could have been different. We wouldn't have been up to 3 in the morning watching this game had the ump made a different decision, or a different call. But it's not clear if I make that from my council account or my Councillor Pappas account, is that an official statement from the county? Surely in the context, I think that's a little bit of a silly example. But when you get into things like election campaigning or discussing issues that are before the county or topics that are going to be discussed in the future, it's really hard to unmarry the two things or to draw separations. And so one example of something done in another jurisdiction, funny enough, in Los Angeles, so this follows well on my Jay's comment, the City of Los Angeles Ethics Commission, which is essentially a fiat for our Integrity Commissioner system, they've published a guide for the 2026 council election. And the guidance they give candidates is that if a candidate is using a social media account to communicate about the election, whether that's communicating their position or their platform, their ideas, giving updates, they're required to include a statement on the homepage or the main page of their account that says this account is being used for campaign purposes by in the name of the individual who's running for office. And what that does is it clearly demarcates or it clearly designates that particular account as being for election purposes, as opposed to, for example, being conducted in one's official capacity. So the overall guidance is that members need to take clear and affirmative steps to distinguish between their official capacity and their private capacity during an election period. And this goes for a number of different topics, but social media specifically is an important one. Two options that members of council might have, and this is something that follows on the recommendations of the City of Toronto's Integrity Commissioner. First option is to maintain a separate social media account for specific election purposes. So say I have my Councillor Pappas, I'm not a member of council anywhere, just so that everyone knows. I have my Councillor Pappas account, and I have my Vote For number 4 Pappas account. I have those two separate Instagram accounts, separately managed. And what that does is it helps uncouple the two concepts. So it's very clear when I'm making an announcement about what council is going to be considering at its upcoming meeting, and then I'm giving my own private take on what my platform points are. That may or may not relate to that issue. The second option is that if you're using an existing social media account that you already have, so this is an example of something that Mayor Crombie, in the city, former Mayor Crombie, got herself into a bit of a pickle in, because she had a website, bonniecrombie.ca, that she'd used for a federal election campaign and also her council campaign and her mayor campaign. If you're continuing to use an existing social media account, there are some guidance or some things you should do. First, cease using that account for your official business or for conducting constituent outreach, for answering emails, and redirect those to a different account or a different medium. Second is to remove reference to the county or county logos or your position on council to, again, clearly separate or demarcate the line between private and official capacity, and remove references to that account from official websites. So for instance, if County of Brant website has links that redirect to constituency websites, those should be removed or changed. So the last substantive issue that I'll deal with are endorsements, and this largely applies to members of council who may not be seeking re-election, but may want to give their 2 cents on what candidates they feel are worth looking at. There's nothing specific that says a member of council cannot make an endorsement, or any person cannot exercise their free expression to endorse another candidate for office. But it's the old adage, and I hate being, or I didn't like being told this as a kid, because it's so true. How you say something is different than what you're saying, or it makes a difference. And so how an endorsement is made, the context in which it's made, what language is used in that endorsement, that's more important than the fact of an endorsement being made. So two things that are important here. The first is, again, the campaign finance regime in the Municipal Elections Act. There's a new regime that came into place as of 2018 that's called the third-party advertiser regime. And essentially where someone wants to make an advertisement either promoting, supporting, or opposing a candidate, and they incur costs to do so, there are registration obligations under the Municipal Elections Act, and there are also a host of campaign finance obligations that are visited. Failing to register is an offense under the Municipal Elections Act. And something that happened in another jurisdiction more recently in BC, the founder of Lululemon, Chip Wilson, was recently fined by BC's elections regulator for posting a large billboard sign out on his front lawn. I don't know if anyone's seen that in the news. And effectively, that sign opposed David Eby, the leader of the NDP, and he was fined because he didn't register as a third-party advertiser in that regime. So something innocuous like a verbal comment or telling someone over coffee that, yeah, I'd support Councillor Pappas for his re-election bid, that's different. But to the extent you're using your official, your social media page, you're using costs to pay for the cell phone that you're doing it on, that could be something that is looked at as a third-party advertisement under the regime. The second is the code of conduct. Again, I've been over undue influence, and we've been over the use of county resources for election purposes. And the extent an endorsement uses or relates to county resources, that could be a violation of the code. One example where that sort of exact situation came up was, again, in the city of Toronto with Councillor Justin DeCiano. That councillor used a service called MailChimp, and that was essentially a distribution list for managing all of the emails that he had in his constituency office. He was using that to send letters. It was a paid service, so what he would do is every month he would pay the fee, and the city would reimburse him out of the office budget expense fund. And so what happened was, in an election year, a staff member from his office went in and exported all the data from MailChimp, took the email list, and DeCiano sent a mass email from his personal Gmail account supporting a candidate that was running in the 2018 election in the city of Toronto. And a complaint was made by an individual who had received this email because the individual, I think, presuming or surmising, felt it odd or felt it inappropriate that that email, which he never gave to the councillor in his personal capacity, was being used to promote another candidate. And the Integrity Commissioner determined that conduct actually did contravene the code provisions that dealt with the use of city property and election campaign work. So by way of concluding remarks and some general guidance, the important thing to keep in mind is, as a member of council, you're always wearing two hats, and I think almost three hats in a sense in an election year. You're acting in your official capacity as a member of council, and you have to serve and be seen as serving the public interest above any other private interest. Where in an election year, this becomes especially important so that the public can have confidence in the institution of municipal governments. And to that end, every step should be taken to avoid blurring the lines between these two capacities. That could be as simple as having two different social media accounts, which I know is something that members of council often will do in an election year. And it could be very careful about expressing views or opinions in an election year. The general guidance or a question to ask yourself is whether or not all other candidates in an election have an equal opportunity to engage in that same activity. Where someone is an incumbent councillor, they will have an official council website or social media account, which another person might have. And there's nothing to, not to say that incumbency is what gives rise to the issue, but using those resources are what will be inappropriate. And ultimately, if there is a blurring of the lines or some issue about complying with the code of conduct, you have the right to seek advice from the Integrity Commissioner. During the election blackout period, there can't be complaints made, but that doesn't mean you can't actively seek advice from the Integrity Commissioner. So with that, I think we're pretty well good for time. We've got about 15, or I suppose 12 minutes, Mr. Mayor, for any questions or discussion that the members of council might wish to engage in.
Perfect, thank you. Questions? I've got some. Councillor Howe, I bet you have some too.
Yes. Thanks very much, through the mayor. Thanks very much. Learned a lot. Deleted a Facebook post already. Specific to social media. Some councillors choose to use social media, some don't. And anyone who is using social media, Facebook specifically, I'm talking about, creates their own Facebook account. The county doesn't set it up. And so if you create a Facebook post that's Councillor Steve Howe's Ward 2, County of Brant, is that considered a County of Brant asset?
Mm-hmm. It could be. It depends on what angle you're looking from it at, right? If you look at the municipal use of corporate resource policy and you parse through what constitutes an asset, that might not, you may not find that, or that might not be included. When you look at the code of conduct and when you approach the question from an ethics perspective, whether or not, I think the question is different, not who owns that or who's entitled to create it, but is that something that relates to your official capacity or your official duties as a member of council? And even though you can create that by yourself, you can choose to do it or not. You can choose to do any number of different things as a member of council, to engage in constituency outreach or publicize some of the services you might be able to offer your residents. That's something I think undoubtedly that would be considered your official capacity. And so to the extent that resource is used to cross-promote something that's a private interest, that's where, as a matter of ethics, that could be something that inappropriately blurs the line.
Okay, thank you. Like I said, learned a lot very quickly.
Questions, more questions? Councillor McAlpine?
This kind of came up before, so I'm trying to think how to word this. If during the campaign, okay, so as a councillor, okay, we're supposed to support, say, a decision that's been made around the table, okay. But during the election campaign, can you speak up against something that you disagreed with that was talked about or voted on?
Yeah, it's a very good question, right? Like I think ordinarily we all say council speaks with one voice. Once a decision is made, you're expected not to continue to advocate for the contrary. And there's actually a recent court case on that. But putting that aside, because it was an interesting case, in an election year, there's obviously going to be that tension. There's obviously going to be the desire to express your official platform or your position on an issue. And again, it's not so much what you say, but how you say it. So how you're communicating that position, whether or not that's inextricably linked or connected to your official role. For instance, if I'm making a post saying, council wanted to paint the fire hall again, I don't agree with this. I was in council chambers and I spoke up for my residents. Obviously, you're connecting that to your official position, your official capacity. I'm trying to think of a hypothetical without really providing specific guidance, because it would all depend on the circumstances. But for instance, if there's a general comment or general platform point in your policy that's maintained in a separate account or separate social media account, separate comments, that might be permissible, but it really depends. It's a fine line to walk. But I think whether or not you can or can't, the code obligations would still be visited on a member of council. So it's a delicate balancing act that I would say err on the side of caution by very, very carefully choosing the words you're using to express what your policy, your platform ideas are as a councillor, or sorry, as a candidate, and as a councillor continuing to uphold the notion that council speaks with one voice.
Councillor Bell?
Thank you, Mr. Mayor. I was looking at some words you wrote here. Candidate may identify themselves as a member of council or committee, but only to say that they've served in that role. How do I share with people that might elect me again what I've done in that role?
Yeah, it's an interesting point, right? And I think that comes out of what you're drawing on is the use of corporate resources policy, right? So where that comes from is a provision that says you can't use a logo, you can't use a uniform, that sort of thing, but you could say, yes, I've served in this role. in a purely private capacity as a candidate and through the campaign accounts and not any sort of official account, I think it would be fair to say that here's what I've advocated for in my role, because those are policy platform points, right? It's not, you're not using or you're not harping on or using some kind of corporate resource to do that, assuming that you're doing that completely privately in a private campaign capacity. But if you're speaking about things that have been achieved in the last term, things you want to continue working on, I think that'd be something that's appropriate to comment on in your private capacity.
Okay, that's helpful. You talked about the ability to give verbal endorsement to a candidate. What if that's reported?
If it's subsequently reported or picked up by the press or something like that, it depends, right? If I'm having a private conversation with a colleague at work, I'm not going to anticipate that the Toronto Star is going to be in my office hearing or picking that up, right? So I think the context matters. If you know you're speaking to the press, or if you know you're speaking to someone who's a reporter or journalist, I think you have to exercise caution or some level of restraint in knowing that what I say here isn't really just a private conversation that might get picked up later on down the road. But appreciating you can't control what the press says about you. But if you're giving an endorsement verbally, or if you're having a discussion with some friends over coffee, and you say, "Yep, Councillor Pappas, I'm going to vote for him again because I really like what he's done in this last term," those sorts of things. You'd expect that's a private conversation, and in the context of where you're saying it, how you're saying it, that's not something that you necessarily do in your official capacity, right? If you're promoting an individual through your official councillor Facebook page, or at a council meeting, at an open meeting, town hall, that sort of thing, that's where the context is more important in that speech.
Thank you.
Councillor Oakley.
Through you, Mr. Mayor. Two questions, one relatively niche. So it's stated one of the exceptions here is rented facilities. I could use a rented municipal facility if I was hosting a campaign event, but I presume in the page above where there's county trademarks, logos, so on and so forth, I'd have to make sure any social media, whether it's videos, photos, whatever, would not contain a logo in the background if I'm at a county facility.
Sorry, I'm just, if you could direct me to the page, I just want to read the
Yeah,
text.
page 15 and 14. So it's stated one of the exceptions to the municipal use of resources procedure, you can use a rented facility. And in the page above, you however cannot use county of trademark logo slogans.
Sorry, you're referring to the slide deck. Sorry, I hit
Yes.
my
Oh, yeah, my
resources policy. Sorry. So the fact of renting a facility is different than things that are used to promote after the fact, right? I think if there's a logo, if you're taking photos at that event, if there's a logo at the background, even the fact of taking the photo, if it's done privately and you can only see a few individuals, you might not be able to discern that, yeah, that's corporate property. But to the extent there's a logo in the background, something like that, that would be inappropriate, or that would be outside the policy.
And then my other question would be, I've seen in the past, typically for sitting councillors running for other elected positions, but I've seen councillors use their official capacity social media account to say, hey, I'm running for this elsewhere. Follow me here if you want that. I'm not going to use it, talk about it in my official social media page. I presume by how this conversation is going, though, however, that in itself would be in contravention of using an official account to promote a private interest.
So that would be something like, for example, if a member of council wanted to run for MPP or for MP or something like that.
So those are sort of the examples I've seen in vitro, but in this regards, I'm speaking to, like, for example, if I was saying I'm going to run again, I have a separate social media account, but then I direct
Understood.
people from my official one. If you want to see what I'm doing in that regard, follow this account. I presume that would still be a contravention.
I think that's right, and I think not necessarily a contravention, but thinking from an ethical perspective, I think that would be right, because you're still promoting the campaign activity through your official channels, right? So that's what you have to uncouple. I don't profess to be a social media expert or anything. I can't say exactly what the most effective way to get the word out there is, but what I can tell you is, from an ethics perspective, there are issues if you're using your official account to cross promote.
Okay, perfect. Thank you.
Councillor Miller.
Just a simple question. The jacket Councillor Oakley has on, he would not be allowed to campaign with that.
That's correct. That's corporate property.
Like,
Yeah.
would that be, like, could he get into trouble for that? You know, something that's, you grab the jacket and you head out?
Yeah, yeah.
Okay. And then I wanted to ask you, because you mentioned balance and things like that, and there's a double aspect during an election year. You do your official capacity representing your constituents. I can see a lot of people saying, well, you're just, you're campaigning, but I mean, all of us here, you get a call or an email from a constituent, you do your best to help them, so any words of advice for that?
Yeah, it depends. Yeah, so if someone reaches out to you and starts talking about your election campaign or your re-election bid, right, and they're sending you emails to your @brant.ca, guidance that's been given by the Integrity Commissioner of the City of Toronto, other Integrity Commissioners, is redirect them to a different resource. So it's, again, you can't control who sends you an email, but when they start engaging with you, what you should say is, thanks very much for your message, I appreciate it. Please email me on this account because that's my proper campaign email address, and I'm keeping separate the two functions.
Okay. It's tough no matter how you slice it, but, okay.
Yeah,
Thank you.
yeah, and it's certainly onerous, but again, it's the right thing to do. Often the right thing to do and the hard thing to do are the same. And that's because by virtue of being elected in the first place, the public placed in you certain expectations that you're going to be pursuing the public interest over your own private interest. There's a number of cases, often from the municipal conflict of interest perspective, that says there's nothing inherent in the role of a member of council to advance their own private interest or advance someone else's private interests. So.
Okay, thank you.
Councillor Oakley.
Yeah, through you, Mr. Mayor, to the presenter, sort of along the same lines as Councillor Miller there. If I'm, I'm going to an event in my official capacity, I have someone volunteer, friend, whatever, take photos. I use those photos for an official post, official sort of communication. Can I still use then the same photographs, same event in then my personal campaign account, as long as I don't link the two of them together?
So I guess the question, or to answer your question with a hypothetical, so say there's a town hall about a development application, and you attend in your official capacity, someone's taking photos of you, and then you use those photos in your campaign literature, if you will. Again, that's a tough one, because you're attending that event in your official capacity. The representation that you're giving through that photo is, this is what I'm doing as a member of council. That's your official capacity. That's the official business, right? Conversely, there have been instances where, and I think that this activity is called glad handing, if you will, where someone shows up to an official event, but they're not there in their official capacity. They're talking to people and cross promoting, or not cross promoting, but campaigning effectively, telling people that they're running for election. That's permitted in some circumstances, but again, the devil's really in the details. But so for something like a photo, something like that, the guidance typically is, no, don't do something like that, because you're still using the resources that the county had expended to host that meeting to promote yourself indirectly. Yeah.
Thank you very much.
Any other questions? I have a couple of questions, obviously. I have a post, Mayor David Bailey, that I post every morning. I haven't missed a morning in 7 years. And I just sort of say good morning, tell them what I'm going to do today, tell them there's going to be a storm, it's going to be a nice day. I don't talk about any other candidates or councillors. I just tell them where I'm going to be and what I'm all about. So when you're talking about an election year, are you talking about a calendar year, or are you talking about the dates that conform to the election?
Generally, at a sort of a principled level, I would say election year total. So that's 2026 total, because come January 1, people are thinking about this. People start thinking that, okay, come election, who's going to be, or come October, who's going to be running, whose name's going to be on the ballot. And the closer you approach the earliest date you can file a nomination, which is the regulated period under the MEA, that's May 1st, 2026, that's when things become incredibly sensitive. So in that interstitial period, January to May, there's still going to be scrutiny, or the public's still going to understand it's an election year. Once people can start filing their nomination papers, that's when things need to be incredibly sensitive.
That's what things
very
have to be
careful.
tightened up. So,
Yeah.
so really, yesterday was a year to the next election, yesterday. So you're not
that's
talking
right,
about that calendar year. You're
No,
talking about
no.
the calendar year which
Yep, calendar year
conform to the dates
2026.
that are mandated. So when that date happens, do I have to forget about everything I've done for 7 years and start something else?
You're still the elected mayor of the county. You're still acting in that official capacity, and you still have official duties. To the extent your daily briefing or your daily social media post relates to what you're doing in your capacity as a mayor, that's perfectly fine to do that. To the extent you're saying, I'm gonna be here for a campaign event, I have a fundraiser somewhere else, then that's when you start to blur the line, so.
No, no, okay. So I would think that I would hate to think that I wasted 7 years of doing something right to conform to something that doesn't seem right to me. So if you were to tell me I couldn't do that anymore, I would find that unfair because of the time that I've put into what I've been doing. But I assure you that it's not talking against anyone or supporting anyone or denouncing anyone. I can't help what people say, but I don't sort of, I don't take that and let them go crazy. I stop them or tell them they can't say that or whatever. But what I do is what I do, and it's very generic, but it's what I do every day. It's consistent, and I would think that an integrity commissioner that got a complaint against me for doing what I do would be able to look back and see that I've been doing what I think is the right thing with no malice.
Yeah, absolutely. And context matters, right? So if you started on nomination day making these posts and promoting yourself, that might be different than something you've done routinely for 2 terms now.
Yeah, okay. Thank you. Any other questions? Councillor Kyle?
Yeah, thank you, Mr. Mayor, through you to the presenter. And this is just kind of to clarify maybe what Mayor Bailey was asking about. So he's good to continue with his posts on his official mayor capacity, but anything related to his campaign for running for re-election, for example, would have to be on a separate
That's
Facebook
right.
page,
That's
correct?
right.
They couldn't, they have to be 2 separate things?
Correct.
Okay.
In a case like that, though, you would suggest probably that I get rid of the first one and just make a campaign.
You could still have both. The guidance from integrity commissioners is that you could still have both, so long as you're not cross-pollinating the content, so to speak.
It's easy to say that, but it's not.
Hard in practice.
It's not,
Yep.
maybe
Yep.
I'm not the one that's gonna be cross-contaminating, because, as you said, the third-party people who declared against me both times that I was elected, like the Home Builders Association, and people that wanna feel you out to see how you feel about growth and things like that, they ran against me both times for third party, just to have me go to their, to speak at their meetings and things like that, so that they could judge how I felt about what they were up to as far as growth and everything. So I can't help anything like that. That's something that will just be put on me if they decide to do it again. Or, I mean, it's not a bad thing, but it was something that I didn't know could happen. So there have been people that have lodged third-party status against me, which is fine at the end, but it's very unsettling to know that anybody can, and they can come out of the woodwork and say whatever they like. And as you said, billboards go up and people say what they want to say. That's just the way it is, I guess.
Yeah, subject to regulations, right? So there's that trade-off, right? You have that right, that ability to engage in that political discourse to the extent you're incurring money to do it. That's where the regulated activity in the MEA comes into play.
Okay. Any other questions? We went a little bit over, but we started a little bit late, so we're right on schedule. So thank you very much for speaking to us.
Thank you, Mr. Mayor. Thank you.
And if there's nothing else? Nothing else? Okay. Let's just make a motion to receive the delegation as information. Councillor Pierce, Councillor Oakley, all those in favor to receive? Thank you. Opposed? None? Perfect. I'm going to ask for someone to adjourn us, noting that there is something to eat in the room next to us before our council meeting tonight at 6 o'clock. All those in favor of the